And then we see what the court does further. The court says, was the interference necessary, right? The court notes in this connection that it has on several occasions examined the complaints under Article 8 of the Convention brought by lawyers in the exercise of their profession. So lawyers do use this often as an excuse for not having to do certain things because it might harm the attorney-client privilege. And in paragraph 120, the court says the question facing the court is therefore whether the obligation for lawyers to report suspicions amounts to disproportionate interference with a legal professional privilege. And this is very much, whether you report money laundering or whether you report aggressive tax planning, I do not see a big difference. But the court says, the court reiterates that for the purpose of Article 8 of the Convention, the notion of necessity implies that the interference corresponds to a pressing social need, and in particular that it is proportionate to the legitimate aim. We see the Court of Justice using the same wording, right? And then the court goes on to say, the court notes that in its judgment, the underlying judgment of Monsieur, the Conseil d'Etat held that requiring lawyers to report suspicions did not amount to excessive interference. It reached that conclusion in regard being had to the general interest served by combating money laundering and to the guarantee provided by the exclusion from the scope of obligation of information in the course of activities connected with judicial proceedings or in their capacity as legal counsel. The court, so the Human Rights Court, finds no fault with that reasoning. So what the court says here is, lawyers had to report, but A, they did not have to do it if they were in legal proceedings, and B, it was only with regard to the money laundering and combating the money laundering, right? And the court then goes on to say it is true that, as previously indicated, legal professional privilege is of great importance for both the lawyer and his client and for the proper administration of justice. It is not, however, inviolable. Its importance should also be weighed against that attached by the member states to combating the laundering of proceeds of crime, which are likely to be used for finance criminal activities linked to drug trafficking or, for example, international terrorism. And the lawyer's legal privilege does not go above that, right? And then the court says in paragraph 124, as to the applicant's argument that the obligation to report is not necessary because any lawyer found to be involved in money laundering operation would in any event be liable to criminal proceedings, the court is not indifferent to it. It considers, however, that argument does not prevent a state or a group of states from combining the repressive provisions that they have adopted with a specifically preventative mechanism. In other words, what I understand the court say here is, you can have reporting rules and you can have backup rules to make sure the reporting is happening. Now, what we just saw the ECJ said is, we already have reporting rules for the taxpayer and other intermediaries, therefore we do not need backup rules. And I think there's a contradiction here between the European Court of Human Rights and the Court of Justice of the EU and how they qualify these things. So the Court of Human Rights go on in paragraph 126 to say two factors are decisive in the eyes of the court in assessing proportionality of the interference. Firstly, the fact that lawyers are subject to the obligation to report suspicions only in two cases, where in the context of their business activity they take part in financial or real estate transactions or act as trustees, and where they assist their clients in preparing or carrying out transactions concerning certain defined operations, buying and selling of trusts or any other similar structure, and the setting up or management of endowment funds, right? The obligation to report suspicions therefore only concerns tasks performed by lawyers which are similar to those performed by other professions subjected to the same obligation and not to their role they play in defending their clients. So this is, discrimination is when you treat different cases the same or the same cases differently, right? And here the lawyer is doing the same as other advisors and they need to report, so why should the lawyer not do so? Furthermore, lawyers are not subject to the obligation where the activities in question relates to judicial proceedings. We saw that before. The obligation to report suspicions does not therefore go to the very essence of the lawyer's defense role, which, as stated earlier, forms the very basis of legal professional privilege. And then the second factor is that the legislation has introduced a filter which protects the professional legal privilege. Lawyers do not transmit reports directly to the FIU, which is the French government, I assume, as appropriate, but as appropriate to the president of the bar of the Conseil d'État. So in other words, you don't report to the government, you report to other lawyers. The court has already pointed out that the role played by the chairman of the bar constitutes a guarantee when it comes to protecting legal professional privilege. Now, the reporting, telling other intermediaries that are not lawyers protected by legal privilege that they need to report is maybe not the same as to report as telling the president of the bar, but still the only thing that you're telling them is that they need to report. You're not telling them what you said. So I think the parallels continue here, and with the parallels continuing, you also see that the CJU and the Court of Human Rights actually came to very opposite decisions on this issue. And then the Court of Human Rights concludes and says, in light of the above considerations, the court considers that regard being had to the legitimate aim pursued and the particular importance of that aim in a democratic society, the obligation for lawyers to report suspicions, as practiced in France, does not constitute disproportionate interference with the professional privilege of lawyers. So why the Court of Justice quoted this case as part of the reasoning that they do, that the EU directive is in breach of legal privilege, I really don't know. I want to conclude with a couple of general remarks about this case. First of all, again, the whole BEPS Action 12 project was started because advisors were selling mass tax planning structures. And the original idea was that the advisors that peddle these structures should report the structures they're peddling. And every infringement moving that obligation to taxpayers themselves is a bit of a pain. And that is what this decision does, right? Secondly, I do strongly believe that legal privilege only should count for criminal cases, or if you want for litigations, but these are not litigations, right? As I mentioned already, as far as I understand, legal privilege is only covered on a national basis. If you're a Dutch lawyer, you're covered by Dutch legal privilege. It does not mean you can, when you land in Brussels on a plane and a Belgian customs or police force asks you to hand over the documents that you have in your briefcase, you cannot say, I'm a lawyer, I'm a Dutch lawyer and I have legal privilege, because you are not a lawyer in Belgium, you are a lawyer in Holland, right? And Belgium is not bound by Dutch legal privilege rules. Other professions deserve no legal privilege if they're not engaged in criminal cases. You do see advisors after this case has been published in December saying, oh, but should this privilege then also apply for accountants? Accountants love to have legal privilege, the same legal privilege as lawyers have, right? But if you're not involved in a criminal case, which you shouldn't be if you're an accountant, you don't need legal privilege. And then the other issue is a practical one, right? I mean, a lot of these lawyers are advising their clients together with a whole bunch of other advisors on I don't know, a structured finance deal, a group takeover where they try to make sure that they save as much tax in the process, or they leverage the tax-paying operating companies as highly as possible so those companies will never pay tax again. And these lawyers are communicating back and forth with PwC and E&Y and I don't know, ABN AMRO Bank, whichever bank it is. And then all of a sudden, when it comes to DAC6, these lawyers now shouldn't tell PwC and E&Y and ABN AMRO, oh, by the way, you need to report this, because they didn't know that the lawyer was involved in the deal. I really think the Court of Justice should have made a carve out and say that you only, as a lawyer, have the privilege if the other intermediaries do not know that you exist in this transaction. But if they already know that because you've taken part in conference calls, because you were CC'd on emails or whatever, or you were making all the contracts and you were sending it to them, why should you not tell them that they need to report and you're not doing it because of you claim legal privilege, rightly or wrongly? I really think the decision should have made a carve out for this. And then the other thing is, does the directive or Belgium law say anything about what must be in the notification, which specifically impedes the lawyer from doing so? You know, the lawyer can just tell the other guys, by the way, we worked on a transaction, you need to report it, I'm not going to do it because of legal privilege. You know, is there anything in that sentence which harms the client either under Article 7 or under Article 7, because Article 47 we've already decided is not relevant, right? I don't see that. This paragraph, no other means criterion in the CJU decision, paragraph 42 that we were talking about, is kills backstops, right? And as I pointed out to you in paragraph 124 of the European Court of Human Rights decisions, they said, we understand that you don't only have one measure, but you have a backup measure. So the CJU and the ECHR are not following each other with regard to having backup structures to make sure that compliance do happen. And then Article 7 applies even when Article 47 is not applicable, which I find an interesting right, because Article 47 is the one with the right to a fair trial, right? But then apparently lawyers can, in EU law, also claim attorney-client privilege under Article 7, which is basic privacy. And it begs the question, you know, does that mean, for instance, that a client and his accountant's correspondence is also privileged? And can accountants now under Article 7 claim, but we should also not have to report as intermediaries? I wouldn't see why not. So I think this is also there's a risk that the CJU has stretched this case way too far. And then finally, I wonder whether the CJAU has stretched this so far because it was ultimately a bunch of judges, being lawyers themselves, deciding about the legal privilege of lawyers. And has there been some element of bias here? You know, I'm not even sure the CJU can have ad hoc juries, preferably consisting of normal taxpayers, for instance, wage earners, in a case like this, not being lawyers themselves. Because I think if you ask the jury of wage earners whether they think that lawyers deserve attorney-client privilege for advising on aggressive tax planning structure, whereby the wage earners need to pay more tax because the companies do not, I doubt that they would have come to the same conclusion as the CJU has come. Anyway, that is it for this week. It's been a long case, but there was a lot of material to cover. I hope you enjoyed it, and I'm sure that some of the things I've said is controversial. Feel free to comment below, and especially if you find that I've done something that is technically wrong, do tell me. The worst that can happen when I'm wrong is that I learn something. Otherwise, I look forward to seeing you next time. Bye for now.